Welcome, everyone. Thank you for joining us for the webcast Background Checks, How to Stay Compliant with the Onslaught of Legal Changes and Updates, sponsored by EPAY Systems. This webcast has been pre-approved for HRCI and SHRM credit. Please be sure to attend the entire webcast in order to receive your credits. You will receive an email from hr.com within 2 business days, which will include your certification credit information. You may also log into hr.com and go to your View My Credits page where you can see the credits you have received. If you have any questions during the webcast, please click on the Q&A tab in your webinar controls and enter them there. I will post a link to the slides and the exit survey in the chat area once the presentation has started. And a new tab will open in your browser with the webcast survey. Please be sure to complete it as soon as the webcast has ended. It is now my pleasure to turn it over to Michelle Lanter-Smith for an introduction.
Hello, and welcome to our webinar today presented by EPAY Systems and our very special presenter from Seyfarth, Jennifer Mora. Welcome, Jennifer, for joining us today.
Thank you.
Today we're going to talk about background checks and how to stay compliant with the onslaught of legal changes and updates. Very, very important topic, something that I'm sure all of us as hiring managers are concerned about, and Jennifer has an hour-packed session ready for you. So there's a lot of learning to begin and get going. Before we do that, though, I'd like to talk real quickly about the agenda on the next slide, and you can see what we're going to cover. So I'm going to spend just a few seconds talking to you about EPAY Systems, and then Jennifer's going to go into the Fair Credit Reporting Act and what you need to know there and be careful of, a litigation update, so what's happening out there in litigation, the litigation world, and then finally going into really the ban the box and best practices and recommendations. So again, it's going to be action-packed and a lot of really good information. Let me just tell you a little bit about EPAY Systems. EPAY was founded in 2001. We're here in Chicago, Illinois, in the Windy City, and we specialize in human capital management. So we offer solutions for employers with hourly distributed workforces where their employees are on the go, they're moving from site to site, going around to different locations, and they're pretty tough to track and to manage and to pay. And that's what we specialize in. So we have a full solution from applicant tracking to onboarding to time and attendance to payroll, and we serve hundreds of thousands of sites around the world in doing so. What we do to really set us apart from some of our competitors out there is we have a leading-edge workforce management solution. We believe that if you can control the labor costs and optimize that labor cost, it really helps that whole business grow and get stronger. Our customers love the support we give. We're very unique in that all of our clients get a 24/7 support. And because of that great support and the technology that really makes a difference in controlling costs, we're happy to say we get a 99% retention rate. And you can see some of the clients that we work with day in and day out. So today, I'd like to tell you a little bit more about Jennifer so that you can understand her background. Jennifer Mora is a senior counsel at Seyfarth in their Los Angeles office. She's developed a special expertise in background check laws, and she regularly advises and defends employers and consumer reporting agencies on the intersection of federal and state background check laws. Jennifer also has expertise on advising clients on federal and state drug-free workplaces and drug testing issues, including compliance with the Department of Transportation and their mandated programs. Also, Jennifer is an author. She's written many articles and given several presentations to national audiences regarding background check and drug testing issues. So we're very pleased to have Jennifer with us today. And with that, I am going to turn it over to Jennifer.
Thank you so much, Michelle. And before we begin, I just want to do kind of our standard disclaimer. I'm going to do my best to give you as much information about the laws as I can in a short period of time. Background checks are something we could talk about for several hours, depending on the subject. But nothing I say today should be construed as legal advice. If you have questions, I would encourage you to talk to your own attorney. You are certainly welcome to contact me as well, but just that's kind of something we want to throw out there. And I appreciate the introduction. I've been doing background check advice and counsel since 2009. I can't believe time flies. That was back at a time when we weren't seeing too much activity at the federal or the state or even the local level. We had maybe 2 ban-the-box laws on the books. We certainly didn't have all of the class action litigation against employers alleging violations of their background check paperwork or their process. And so it was kind of one of those things that, you know, I just did in addition to my regular employment practice. And then at some point it exploded. And I do my best to really kind of breathe and sleep these laws. And so I'd like to think that you're in good hands. If you have questions, please definitely ask. We're going to have time at the end for me to answer some additional questions. If we run out of time, again, you can drop me an email. I'm not going to bill you for it. I'm always here and available to help. So I want to talk about the Fair Credit Reporting Act, which is the federal statute that regulates employers that order background check reports for employment purposes. Now, before I go into what all of this means, I want to make sure everybody understands on this webinar that the title, the Fair Credit Reporting Act, is somewhat misleading insofar as if you didn't know much about the statute, you might assume that it only applies to credit reports. I'm here to tell you that is not true. The FCRA, despite its name, applies to any background check information that you obtain from a consumer reporting agency about an individual. So if you're using any of the big background check companies or small ones out there, but you know, some of the bigger ones are Sterling or Higher Right, and some of the smaller ones might be Higher Image. You know, there's a bunch of them out there. If you're using any of those companies to background your employees and the background report maybe never even includes credit. Actually, in my experience, most employers don't order credit checks. But if you're getting criminal history reports, motor vehicle records, education verification, employment verification, that is all subject to the Federal Fair Credit Reporting Act. Before you order a background check, sorry about that, before you order a background check on an applicant or employee for employment purposes, you have to provide them a disclosure in a document that consists solely of the disclosure that a consumer report may be obtained. And we'll talk briefly about how this consisting only of the disclosure has been resulting in a lot of litigation against employers. There was a time when employers were including their disclosure and authorization directly in an employment application. They were burying it in other pre-hire documents. Really, your disclosure should be in a standalone separate document. When I have clients that come to me and they want me to prepare forms for them for this purpose, I always include the disclosure on one page. It's 2 short paragraphs, nothing else on the page, and then the separate page has the authorization that the person signs. We'll talk about it shortly, but there's just been so much class action litigation against employers, and a lot of times, you know, the people that are bringing these lawsuits, they weren't even rejected because of a background check report. They just, you know, got a copy of the disclosure, saw that it was problematic, and found a lawyer willing to take their case. These FCRA cases really are kind of turning into like the new wage and hour class action, where, you know, the people making money really are the plaintiff's attorneys. There are a couple of state and local requirements to consider. In California, Minnesota, and Oklahoma, on your authorization, there should be a checkbox that basically says, you know, check here if you would like a free copy of your report. That's just for California, Minnesota, and Oklahoma. You certainly can include that nationwide if you want, but really you're only required to do that in these 3 jurisdictions. Okay, so let's say you get a background check report on somebody and it has some information in there that is concerning to you. Maybe they have an assault conviction, maybe they have some pending charges, maybe the education background check that the vendor did for you shows that the person didn't have a degree when the person's resume says they did. Whatever it is, if you think that you're going to take any sort of adverse action against somebody and that reason is based in whole or in part on the information in that report, and that decision is adverse to the consumer, which here it would be, you know, rejecting them for a job or possibly even terminating them if this is a check you ran during employment and you found out about something troubling to you. you have to follow what's called the pre-adverse and adverse action process. Now, what does it mean where it says an action taken based in whole or in part on the report? That means that the background check information doesn't have to be the sole reason. If for some reason you find out something else that's completely unrelated, and that's part of the reason you're not going to hire them, but also the other part of the reason is this 5-year-old assault conviction that came up in the report, then you do have to follow the pre-adverse action process. So if the background check matters at all, then the process is required. And so the first thing you do is you provide them a pre-adverse action notice. And this is a notice that you give them before you actually take the adverse action. It's a very short notice, and we're going to talk about later on about any specific local requirements that have to go in these notices, but this is just kind of the federal rule. You basically say in the cover letter, you authorized us to obtain a background report on you. Attached is a copy of the report and a summary of your rights. If there's any state or local notices, which we'll talk about, those are attached as well. Please take a look at the information in the report. We may be rejecting you or terminating you, whatever the case may be, based in whole or in part on the report. If there's anything in here that's incorrect, or you'd like to, call us and plead as to why we should, still hire you, even though you have this report, please do so. We won't make a decision for at least 7 days. That's really kind of the point of the report, the point of the notice is to give them all of this information. And it's really to make sure that it's kind of, if you look at it as like a due process issue, you're telling them that they may lose a job opportunity because of their background, and you want to make sure they know what's in their background and that they have time to raise any issues. So you want to make sure that you're not taking the actual adverse action during this process. And what the statute requires is that once you send the pre-adverse action notice to the person, you then have to wait a reasonable period of time. The Federal Trade Commission, which shares enforcement responsibility for the FTC, has set in some opinion letters that 5 days is okay. Some local laws have a defined period, like in New York City, you can't do anything for at least 3 days after the day they receive the letter. You'll always want to make sure you follow the longer period. I think San Francisco is 7 days. But you'll see on this slide, we consider the mail period. One of the things that's been interesting is that even though the FTC has said that 5 days is okay, some plaintiffs' attorneys have started saying, well, if you put the letter in the mail, they really kind of lose 2 days. And so if you're only giving them 5 days, they really only had 3 days to consider the information. So typically what I advise employers to do is to give them 7 days, essentially a week. You can always expedite this by overnighting the letter. Whether or not you can email the letter is kind of up for debate under the statute. There are kind of ways to deal with that. But just make sure that they have a good solid 5 days to consider the information. So you'll want to think about that whenever you pick your delivery mechanism. If we assume then that the person doesn't contact you, maybe they don't change your mind, they don't have any information to share, they don't file a dispute, or they do contact you and whatever it is they have to tell you doesn't change your mind, and that happens a lot, then you can send them the adverse action notice. And this is the notice where you are actually telling them, okay, this is our final decision. Between the time you send the pre-adverse action notice and the time you send the adverse action notice, the applicant needs to be told and believe that, well, not believe, but they need to be told, and it should be true, that you have not made a final decision. You as the employer have not made a final decision. You are giving them a meaningful opportunity to let you know. And so therefore, you don't want to tell them on the phone, we're not hiring you. If they call the day after they get the pre-adverse and start asking a bunch of questions, well, what does this mean for me? You're just going to want to tell them, look, if there's information you want to give us, please do. We're still making a decision and we'll be in touch. So you're kind of just like ensuring that this process plays itself out the way that it's supposed to be, because I'll talk shortly about a case where this turned into an issue for somebody, an employer, I should say. The adverse action notice has specific information that's required by the Federal Fair Credit Reporting Act. You have to include your vendor's contact information. You have to say that the vendor, your consumer reporting agency, they're not the decision maker and they can't give you reasons for the decision. This prevents the consumer applicant employee from calling the vendor and bombarding them with questions that they don't even know the answer to. They have a right to get a free copy of the report. They have this right, and it must be in the adverse action notice, even though they got a copy with the pre-adverse action notice. If they want to get another free copy, they can. And then you advise them of their right to dispute with the CRA the information in the report. A lot of times questions will come up, well, what if somebody files a dispute in the 7-day window? Do we have to wait? The answer is you don't have to wait, except in New York City. In New York City, as part of your individualized assessment, you're supposed to consider whether or not the information is accurate or corrected. And the only way you can do that is if you wait for a dispute to play itself out. What I typically tell clients to do is if somebody files a dispute, then find out what the nature of the dispute is. If it seems like a valid reason, something that may actually result in the changing of the report or correction to the report, and you like this candidate, you might want to go ahead and wait. Oftentimes, you know, there have been times when, you know, somebody will say, I was wrongly convicted, and, or, you know, my girlfriend filed, I was just dealing with this one that these charges are baseless. It was some pending domestic violence charges, and the guy said she was retaliating against me, and it's, you know, I mean, as an employer, what do you do with that, right? So I just tell clients to consider the nature of the dispute and then make a decision. Are you legally required to wait the 30 days that the CRA has to investigate? No. But, you know, I would take it on a case by case, because you never know. You don't want to lose a really good candidate just because of some screw up from, you know, the vendor reported something that they shouldn't have reported or that was wrong or what have you. You know, there have been situations where people have said they were the victim of identity theft and they were able to prove it. As part of this process, you'll certify to your vendor that you have a permissible purpose. That'll be in your end user agreement. You'll also be certifying to them that you have provided the standalone disclosure and obtained consent, and that you'll follow this process. So this will all just be kind of very technical legal language that's in your end user agreement with your vendor. Our firm does a lot of work for vendors, the consumer reporting agencies, and I have yet to see a contract that doesn't have these certifications. So this isn't something that you need to contact your vendor and say, am I including these in the end user agreement? Because they're all there. But I just wanted to let you know. Commonly alleged FCRA violations, like I was talking about earlier, we're seeing a lot of class actions. That started, I want to say around 8 or 9 years ago, possibly. And what really started it was that these disclosures had liability releases. So it would say something like, you know, I authorize you to order a background check on me, and I release everybody under the sun from any and all liability and claims in connection with this process. That's huge. That's a huge problem. If that is in your background check paperwork, please call somebody immediately to have that fixed. The other issue is that sometimes the disclosure is commingled in an employment application. The disclosure might have state law language. There have been allegations that including the name of the vendor in the disclosure is problematic. And then there have been some allegations that including credit in there when you're not actually getting credit could be an issue. So, you know, it's always a good idea to have your counsel review your FCRA paperwork, I'd say annually, just to make sure that it's, you know, it's good in light of what we know. You know, a lot of times it's fine based on the courts, but then plaintiffs will start coming up with these new creative ideas. And some of them might be silly, but if they're an easy fix and you can prevent a claim against your own company, then you might as well take advantage of it. In terms of adverse action process issues, what we're seeing with those claims, those will only turn into a class action if you have just a national problem of not providing pre-adverse and adverse action notices. But a lot of times the pre-adverse won't have the report, it won't have the FCRA summary of rights, it'll have the wrong outdated summary of rights. Speaking of that, as of a month ago, the Consumer Financial Protection Bureau, which shares enforcement responsibility with the FTC, issued a new FCRA summary of rights, so make sure you're using that one. If you're not sure, just Google consumerfinance.gov FCRA summary of rights, and it'll take you to the latest. But you do want to make sure you're using the most recent version, because there are a ton of them on the internet and a lot of them are outdated. And then in terms of the process, what that looks like is not waiting a sufficient period of time, maybe waiting 2 or 3 days instead of 5 to 7, and rejecting somebody ahead of the pre-adverse. And so that leads me into the case I wanted to talk about, where, excuse me, the employer relied on the vendor to send the pre-adverse action and final adverse action notices. just so everybody on the call is aware, you can outsource this function to your vendor if you want. I know that a lot of vendors do it. They do charge per letter to do it. That's perfectly acceptable. Just realize that this is an employer obligation. And so even though you're outsourcing it to somebody else to do it for you, you as the employer have the obligation of ensuring it's done properly. So I encourage everybody on this call, if you're having your vendor handle your pre-adverse and adverse action process, that you occasionally check to make sure that, you know, that you like the notices, that they're actually waiting, that things are going out. Because if there's a lawsuit, they're going to sue you and possibly the vendor too. So what happened in this case is that the employer, again, like I said, relied on the CRA to send these notices. But what the talent acquisition manager did was they kind of added something to the process, which was they sent an email to this particular applicant. And the subject line said, urgent rescinded offer. Well, what does that tell you? That your offer was rescinded, right? The decision is done. I'm not getting a job. You rescinded my offer. But then the email was a bit weird because then it said, hey, you're ineligible for hire. Great, that's what the subject says. But let us know if there's a mistake in the report. And oh, by the way, you're going to get a notice from the third party, which they were referring to the pre-adverse. That email goes out. The CRA then sends out the pre-adverse action notice. And the plaintiff sued, and the plaintiff said, you advised me of the final decision before I got a pre-adverse action notice. And I don't know how this case ended up, if it's settled or if it went to trial. My sense is it's settled, but what happened was the employer filed a motion for summary judgment, and that's basically a motion to dismiss once discovery has been concluded. And the employer said, look, even if what he is alleging is true, we still win, because the email specifically said that he could let us know if he had information or if he had anything he wanted us to know about to change our mind. And oh, by the way, we said he was going to get a pre-adverse. And the court said, well, yeah, but the jury could also read it the other way, which is that you made the final decision. And when it's kind of a factual dispute like that, the judge is always going to say the jury has to decide, because that's not the judge's job. So because of this, I mean, ultimately, the talent acquisition manager was trying to do a good thing, like give him a heads up that this notice was coming. But that one little added piece to the process resulted in a lawsuit, and a very expensive lawsuit that probably settled. So this is just kind of a reminder to everybody on the call to make sure that your process is buttoned up, and you really want to train to managers or anybody who might be getting phone calls from the applicant. Let's say somebody gets a pre-adverse and they want to start, the applicant wants to start calling a bunch of people to find out what's going on. Anybody that you think might be getting a phone call from that applicant should be told, you know, don't give the details of the background check, but just say, hey, something came up in the background. If he calls, you know, send him to us, or be sure you say X, but don't say Y. Because any little, you know, I've seen a lot of situations where a manager will get the call and he'll say, well, I really want to hire you, but HR is saying I can't because you got this. And now you kind of have a technical violation that you really can't unfix. So this is just an important thing to think about. And this gives you an idea of how serious these adverse action settlements are when the process is just not done right. Now, again, these are class actions, which means we're dealing with a systemic problem. It's not like a one-off like what I just talked about. But if you are dealing with thousands of background checks a year and there's some sort of glitch in your process with respect to everybody, then you can see you can be dealing with $1 million to $4 million settlement for an adverse action claim. So it's definitely something to think about. Issues with respect to the adverse action process, you know, who's the user? This comes up a lot when you have a staffing agency relationship, and so who's using the report, who's making the decision. Maybe the staffing agency is ordering the report, but then they're sending the report to the employer, and then the employer is the one making the decision, but then they're asking the staffing agency to handle the process. These types of arrangements, I've actually done presentations for a full hour just in the staffing agency context, so I can tell you it gets a little complicated, particularly with respect to FCRA and ban the box stuff, which we'll be talking about. You know, what constitutes an adverse action? one of the issues that comes up is if you give somebody an offer date, a start date, and then you find out something and then all you want to do is push back their start date, is that an adverse action? Some people have claimed that it is. And so, you know, it might be better now, if you can, to not have official start dates until somebody's background check clears. Let's see, we talked about the timing. Does the user have to consider the dispute? I've already talked about that, and we're just getting very conflicting opinions from courts on how to handle the adverse action process. You know, these are just some case decisions that you'll see when you download the slides. I'm not going to spend a lot of time on them. I'm just looking to see if there's anything that stands out to me. And this is just a summary of the disclosure and authorization requirement. Just make sure that it doesn't have extraneous information. We're seeing some cases. Extraneous information is basically text that really doesn't belong in the FCRA disclosure. And I talked about what started all of the litigation was the release of claims language. But the other thing we're seeing too is that some employers like to include at-will language in there. I mean, that's really not necessary, and employers are getting sued because of that. I've seen some employers, I think one large employer here in California get sued because they had language that said that the employer could share the report with a third party. So just be very careful, because a lot of the language that you think may be protecting you, you can have in different documents, and it really just will expose you to a national class action issue. Okay, ban the box is something that I actually tend to deal with a lot more than FCRA stuff, just because it's so complicated. So ban the box, what is that? That refers to the box on your employment application that asks people, have you ever been convicted of a crime, or have you been convicted of a felony, or whatever variation of question you have. The first two states to start the trend were Hawaii and Massachusetts quite a long time ago. And then you can see from this slide that it's really just blown up. You know, we're all over in terms of states. We've got some cities, we've got some counties, just all over the place. And the sad part is that, you know, these cities and counties, and states, they're not calling each other and saying, hey, what can we do to like come up with a similar law to yours so that we're not making it difficult for national employers. And the reason I say that is because you'll see that there's just so much variation in terms of what these laws require. I'm glad you'll have these slides, because that way I don't have to read out the jurisdictions. We'll talk about the adverse action requirements, the additional adverse action requirements. We're going to focus on Los Angeles and New York City, because those are the most onerous ban the box laws in the country, and the ones that really require the most modifications to your FCRA pre-adverse and adverse action notices. So like I said, all over the place in terms of when you can ask. Hawaii, Baltimore, Columbia, Portland, Washington, D.C., and California are all after a conditional offer. This should also have New York City. We've got after selected for an interview, after the initial written application, after they're selected for an interview or a conditional offer. So sometimes people they don't even go through an interview, although I've never dealt with an employer that doesn't at least make people go through one interview. Washington and Kansas City, you have to wait until after the person is deemed qualified. That is defined in the ordinance, so at least you'll know what that means. After a first interview, during the first interview, during an interview, after the first interview or a conditional offer. Chicago, after applicant is selected for an initial interview and notified of the interview, or after a conditional offer. So it's just all over the place. And then oh, there's New York City. Okay. Seattle, after the employer has completed initial screening of applicants to eliminate unqualified applicants. And then Austin, Los Angeles, New York City, and Philadelphia. The reason they're not included in the first after a conditional offer slide is because these are a conditional offer that is only conditioned on the results of the check. So this is kind of creating some problems, because a lot of times employers like to have other contingencies on people actually starting. So they'll have an offer letter and it's got, you know, this is contingent on a drug test and a background check and, you know, whatever. And these laws essentially say you have to clear all contingencies before you run a background check. then make the offer, and then run the check. It gets a little bit tricky, but it's really not particularly challenging. One of the questions that comes up, though, in light of all of this is, does this mean that we should nationally wait until after a conditional offer of employment to order background checks? And the answer to that question really depends on your organization. I know there are a lot of lawyers out there that are just telling employers, just do this nationwide, that way you don't have to deal with it. That sounds great in theory, but you may be running so many background checks per year dealing with so many applicants per year that you want to be able to screen people as early as you can in the process in jurisdictions where you're allowed to. You can imagine a situation where if you had a national rule that you wait until after a conditional offer, and maybe you're dealing with 50,000 background checks a year, that's a lot of money spent on background checks when you could have asked them earlier to self-disclose their criminal history. You could have run the check sooner. You can save time in terms of resources with managers doing interviews. So there's a lot of reasons why having a national rule that you wait until after a conditional offer just may not work for your business. It is easy, and if it's feasible and you're fine with it, great. Then you don't have to worry about changing your process anytime a new background check law comes out. But I will tell you, there are a lot of national employers that are still running background checks earlier, or asking people, have you been convicted of a crime on an employment application, where they're allowed to. It's totally business specific, so it's something to consider when you hear people say just wait. Just think about, okay, does that really work for our business, for our organization? Because the answer is it might not. Some of the ban-the-box laws have limits on how far you can go back in terms of considering criminal history information. I don't think this presentation is going to go into all the laws that do have restrictions on how far you can go back, although I think that they're pretty much all here, but I'll throw in the additional ones. So these are just ban-the-box laws. The ones in bullet 1, you can go back as far as you want under those laws in terms of, if you want to consider a felony that's 20 years old, great. In Hawaii and Seattle, it's 10 years, and actually that should be Washington. Hawaii and Washington are 10-year rules. Philadelphia and San Francisco are 7-year rules. So in Philadelphia and San Francisco, you cannot consider convictions that are older than 7 years. In Philadelphia, that is, in determining whether or not the conviction is older than 7 years, you exclude any period they're in jail. So let's say, for example, they were convicted 10 years ago, but they got out of prison 5 years ago. That means that it's still within the 7 years because you're excluding how long they were in jail. In San Francisco, you measure the 7 years from the date they were sentenced. So it doesn't matter when they got out of jail. If they were sentenced more than 7 years ago, then you can't consider it. It doesn't matter how serious it is. It doesn't matter if it's a felony murder conviction. It's off limits. Now, there are some employers that will not care, and they will make a decision based on that. That's great. That's up to them. That's a business decision they make, but I'm just letting you know that what the law is there. There are some exceptions if you're a regulated employer and federal or state law says you can't employ somebody with X conviction regardless of when it happened, then you're going to be exempt from that. But if you're not a regulated employer with any sort of exemptions or requirements on background checks, then you've got to follow these rules. Massachusetts, you can't consider misdemeanors that are older than 3 years unless the person was convicted for any other type of offense within the last 3 years. That actually used to be 5 years up until this month, I think. There was a recent change in the law. They amended the ban-the-box law, and then they changed it to say that misdemeanors over 3 years are off limits. And then New Jersey is kind of really depends on the crime. And then this just shows you kind of the coverage of some of the ban-the-box laws in terms of how many employees you have to have. That'll be in your slide when you leave, so I don't want to take up too much time on that. As I mentioned, some of them have exceptions. In fact, I think most of them do, but we didn't include, this is not an all-inclusive list, but just to give you some examples, these are all the jurisdictions that have some sort of an exception if you have a state or federal law that requires you to consider or says you can't consider somebody or can't hire somebody with a certain criminal conviction. So like I said, like hospitals and police departments or banks. A lot of employers in the financial industry are subject to an exception, and then same with Austin, Texas. Okay, so just a couple of other substantive things to keep in mind. Massachusetts has a rule that you can't consider first convictions for drunkenness, simple assault, speeding, minor traffic violations, or disturbing the peace. These are just kind of your petty misdemeanor offenses. Chicago requires an individualized assessment of various factors if you want to reject somebody because of a criminal record. You also have to, in your adverse action letter, identify the specific information. So, you know, that doesn't mean that you have to explain your assessment or you have to say your conviction is job related because X, Y, and Z. It just means somewhere in your adverse action letter you have to say, you know, our decision was based in part on the background report and in particular your 2010 assault conviction, something like that. Washington, D.C. has a very unique rule that is nowhere else in the country. If the applicant requests an explanation as to why they were rejected, and if the decision was based on their criminal history, then the employer has to provide all records relied on, and then a statement of denial for each factor listed in the ordinance within 30 days. And the factors really relate to, they're similar to the individualized assessment. So how long ago did it happen, and what were the facts and circumstances, and what's your evidence of rehabilitation, stuff like that. So if you're in DC and you ever get one of these requests from people, don't just set it aside. You have to actually respond. You don't have to do that anywhere else. Whether you do so is entirely up to you. Montgomery and Prince George's counties, similar to what I said for Chicago, your notices have to include the specific items. These jurisdictions require a 7-day period. As I mentioned earlier, FCRA apparently it's 5, but I tend to recommend a 7-day rule nationwide because it covers all jurisdictions, and it takes into consideration the mail period, and so then you should be in a better position. If you ask employees or applicants in Seattle, Washington, have you been convicted of a crime, they are allowed to exclude convictions that have been the subject of rehabilitation. Note in New York State, anytime somebody has a certificate of rehabilitation, you have to consider that as part of your assessment. You can't ignore it. And then in Seattle, you have to identify the specific records and hold the job open for 2 business days. And that's really going to kind of happen if you're following the pre-adverse and adverse action process with my 7-day recommendation anyway. Portland, I'll just keep going through a couple more slides with some jurisdiction requirements. Portland is arrest history that did not lead to a conviction. That's actually the law in pretty much most jurisdictions anyway. So if you have somebody who was arrested 10 years ago for something and they were never charged and it went away, you really shouldn't be considering it. I mean, it just opens you up to a bunch of claims. The EEOC doesn't like it. Any sort of arrest or charge that did not result in a conviction is suspect. Juvenile records, again, that's kind of becoming a nationwide trend. Records that have been voided or expunged, or things that have gone through a diversion or deferral of judgment program. I will say that I would say like half the time when I get calls from clients regarding background check issues, it's usually because there's a diversion or deferral of judgment and they don't know what it means, and we have to kind of look at the state law to see what it means. A record has been sealed or expunged, but somehow it showed up in the report, and an employer really can't unsee something it shouldn't have seen in the beginning. So a lot of times the questions that I get have to do with what we call non-conviction records. So there's a record out there, but it didn't actually result in a conviction. So what does it all mean? In Portland, you have to identify again, another example of one where you have to list a specific record in the notice, and you can't do this by voicemail or text, which I would never suggest that anybody do anyway, because you always want to have some sort of record documenting that you did what you were supposed to do. And finally, New York, Buffalo, Rochester, New York City, you have to consider Article 23A. I will talk about that on the next slide. Columbia, Missouri, there's an individualized assessment requirement. And the individualized assessment is very similar to what we see in the EEOC context, where the EEOC recommends that you not consider conviction records unless you do an individualized assessment considering the 8 factors. And I kind of glossed over them a bit but they were how long ago did it happen, how old were they, you know, kind of doing a really big picture look at the conviction to make sure you're just not excluding people with criminal records and then you get some sort of disparate impact claim. San Francisco is one of the ban-the-box laws that actually goes a little bit above and beyond. Like I said, it says that you can't consider convictions that are older than 7 years. You also cannot consider, this is new in San Francisco, decriminalized convictions. And I'm sure you can all guess what that's supposed to cover, which is recreational marijuana. So if somebody has a recreational pot conviction from 3 years ago, it's really off limits in San Francisco because now pot is legal in California, so it's been decriminalized. So that's something to think about. San Francisco, very similar, again, listing the adverse decision, giving them 7 days. And then the OLSE, that's the Office of Labor Standards Enforcement in San Francisco. They have this poster that you're actually supposed to post in your workforce, so your break room or any place in San Francisco where you have employees that advises them of their rights under the San Francisco Fair Chance Ordinance. That form was just updated as of this month. It is now in Chinese, Spanish, and English. And you also have to provide people with a copy of that form / notice before you make any sort of inquiry about their background check. So what I do for clients is when they have their regular FCRA disclosure and authorization, I attach to it a copy of the San Francisco notice. So I want to talk about I mentioned earlier that I was going to talk about New York City and Los Angeles because they really are the most onerous laws in the state, and in the country. And at one time it was New York City, then Los Angeles came along and decided they wanted to outdo New York City in this regard. So Article 23A, that refers to a New York state law and the correction law that says that anytime an employer wants to potentially reject somebody because of conviction, they have to do an 8-factor analysis. And the 8 factors are specifically in the statute. They're similar but somewhat different to the EEOC factors, which I talked about. It is considered per se discrimination in New York State to not do this review. So if you are categorically rejecting people in New York, if you're using any sort of grid that has automatic exclusion rules, that is a problem in New York State. And I would highly suggest that you work with your counsel to change that as soon as possible. New York City, though, they have a Fair Chance Act, and they've created what's called a Fair Chance Act process. So we talked earlier about under the FCRA, if you're going to take action against somebody, you provide them a pre-adverse, you give them the report, you wait about a week, and then you send the adverse. New York City, they have a city form, it's called the Fair Chance Act Notice, and you have to document your review of the Article 23A factors on that form, and you have to give them a copy, give the applicant a copy of that analysis with your pre-adverse action notice. You also have to provide the person a copy of any other document that you considered as part of the review, include the FCRA Summary of Rights, and keep the job open for 3 days, which you're presumably going to do if you're following my 7-day recommendation under the federal statute. Once you provide them all of that under the New York law, then you just follow the normal process. Like I said, if somebody does file a dispute, you are going to want to wait for the vendor to investigate and determine whether the dispute is valid or not. I would say in my experience, most vendors have their investigations done within a week. So it's not like, I mean, technically by law they have 30 days, but it's not like they're really waiting unless it's a particularly difficult record to obtain. Some counties are very ridiculous in terms of how fast you can get records. But in New York City, you do have to wait for a dispute to play itself out if somebody submits a dispute. But otherwise, if they don't and a week has passed, then you can go ahead and just send your adverse action notice. You don't have to do anything else with respect to that Fair Chance Act notice form that I talked about. You're kind of done. But I will say that New York City is very aggressive. That agency is far more aggressive than Los Angeles. I do know Los Angeles is getting more aggressive, but New York City is very, very busy. And so if you are in New York City and you're ordering background checks, I would highly suggest working with your counsel to make sure that you're up to date on this New York City Fair Chance Act. And then Los Angeles had to go a step further. So Los Angeles is pretty much the same as New York. Los Angeles itself has put out its own form, similar to the New York one that I talked about, and the factors on that form track the EEOC individualized assessment factors. So what you do is, with your pre-adverse, you complete that form, you include a copy of the form with the pre-adverse, and you send it off to the adverse. If you look at the third bullet, if the applicant provides you any sort of information, let's say they send you a certificate of rehabilitation, let's say they send you something showing that it should have been a misdemeanor instead of a felony, let's say they send you a letter saying I'm in rehab now, or I went to rehab and I'm sober, and I volunteer and help children. You then have to take that original form that you completed. At the very bottom, there's a reassessment portion. You have to then take the new information the person gave you and do the reassessment at the bottom. You then, with your adverse action notice, if you decide that the information the person gave you does not change your mind, you then have to include that reassessment with the adverse action notice. So compare that to New York City, where I said you fill out the New York City form, you include it with your pre-adverse, wait a reasonable period of time, send your adverse, you're good. LA, you have to consider in New York, you have to consider whatever they gave you, right? But you just don't have to document it like you do in LA. In LA, you go back to the old form, complete the bottom part, and then give that to them with the adverse. So that's what makes out Los Angeles, in my opinion, the most onerous law in the country. Los Angeles, I know one of the questions I'm probably going to get is, how do we know which law applies? Let's say you have somebody applying for a job in Florida and they live in LA. Which law applies? Well, we know that the LA law, based on its language, says it only applies if the job is in LA. So I would not suggest that you follow this process for somebody who lives in LA but is applying for a job in Florida. But if the reverse is true, if they're in Florida and they're applying for a job in LA, then yes, you're going to apply the LA law to that Florida person. It gets a little bit more tricky. I actually just got a call yesterday from a client that wanted to know, we had a situation where somebody was living in Georgia and they were applying for a job with an employer that was based in California, but the person was going to be working in Georgia out of their house. So do I apply the California ban the box law too, or just the Georgia law? And when it's unclear, because in that situation it's a bit unclear, I always tell clients to follow the law that is most favorable to the applicant. And sometimes that just means, a little bit more you have to do with that particular person, but at the end of the day, it's not too much, fortunately. But so to answer the question, some jurisdictions we know the answer, some we really don't. It's kind of one of those where you should reach out to your counsel to kind of get some guidance on which law do I want to apply to this fact pattern. One thing I will say is that what's not relevant is where the person was convicted of a crime. Somebody could be convicted of a crime in Texas and be applying for a job in California, and that doesn't mean that you apply Texas law. You would apply the California law. So it's really, where does the person live and where do they work? Where they have their various convictions is usually a side issue. So again, yes, you might want to consider asking after a conditional offer, have you been convicted of a crime? Again, that depends on your business. If you want to, in Texas, continue to ask people early on in the process, except Austin, have you been convicted of a crime? You can. Florida, Georgia, a lot of the Midwest states, you can still do that, and that's totally up to you. If you have a national employment application, you'll want to make sure that people are advised where they can skip the question. I will say that in New York City and LA and DC and Philadelphia, you cannot have an employment application given to them, a person in those jurisdictions, that says, have you been convicted of a crime? But oh, by the way, skip this if you're here. So if you're a national employer and you want to do that, you would actually have to have two separate employment applications, one for those high-risk jurisdictions and then a different one for everywhere else. I always recommend that you not ask about arrests that didn't result in a conviction, as well as anything that's sealed, expunged, restricted, juvenile records, or pardon records. It's always a good idea to do a job-related analysis. It keeps the EEOC off your back. And as I talked about, like in New York, it's required in some jurisdictions. We always recommend centralizing your background screening role. It gets very unwieldy if it's decentralized, if you have managers in Florida doing one thing and then people out in Oregon doing something else. And then what if you have an African-American applying for a job with an assault conviction and then a non-minority apply for the same role with the same conviction somewhere else? The minority is not hired and the non-minority is. That's a problem. So that's why it's always good to centralize this process if you're able to. I suggest doing an annual review of your policies, applications, and procedures so you can stay on top of what's happening out in this crazy, crazy arena. And definitely take a look at your FCRA and specific adverse action process requirements, because that is where we're seeing most of the litigation. We haven't seen any class actions in the ban the box world yet. That's not to say that they won't happen. A lot of the ban the box stuff is agency complaints, and then the agency is just helping one person. I know there have been a couple settlements up in New York regarding larger retails that have kind of more systemic problems, but ultimately the largest class action risk issue is going to be with FCRA and with FCRA compliance. And then just to wrap it up in terms of best practice recommendations, again, review your disclosures and authorizations annually. If you have outdated disclosures and you swap them out and start using new ones, follow your record retention and get rid of them when you can. I always recommend you keep your disclosure and authorization separate. And then if you are going to have some sort of release of liability, make sure that it's somewhere else away from your FCRA paperwork, because that is a huge, huge red flag. And then I talked earlier with respect to adverse action, train your managers and recruiters on what they can and can't say during this process, because as I told you, one little slip up can result in a lawsuit. Turning off auto rejection letters, a lot of employers and sometimes in conjunction with their vendors will have it set so that letters are sent automatically. And as you've seen, there are some jurisdictions where you have to kind of slow down the process and possibly do things differently. And it could, that process could get a little screwed up if you have an automatic, an automatic system where a letter is kicked out and the person got it sooner than they should have. We talked about, position of location and address, notices, what laws apply. Again, that's one I would suggest reading out on your counsel. Be sure you stay on top of ban the box laws. My firm publishes on them, the second they come out. This is a big one. I strongly suggest, unless you absolutely, absolutely have to, do not allow people to start working before a check is done. I cannot tell you the number of times I've seen situations where someone was eager to get somebody to work and then something came back on the background check, and now we have to go through this pre-adverse action process. You can't fire somebody just because they had a bad background. The FCRA pre-adverse and adverse action process and that waiting period applies to your existing employees. And as I'm sure you all on this phone would agree, it is a lot easier to reject a job applicant than to fire somebody. So unless you're having a dire emergency and you absolutely need somebody to work, I would highly suggest that you change any process that's allowing people to start before the check is done, because it just always creates issues. It never turns out well. Using language like, we're going to review the check. If you have any sort of documents or policies that talk about doing an individualized assessment, make sure you use reviewed. I don't use fail or stuff like that, because it's just a huge red flag. That's what I talked about. Ineligible for hire, requires some sort of action. Again, this is avoiding the auto rejection letters. Wait at least 5 business days and ensure you have mailing time. Again, consider any dispute filed before you send the adverse action notice, because maybe they have a valid dispute. And then follow the ban the box laws. I know this is getting somewhat repetitive, but just to really sum up this time, if you go back and you haven't looked at your FCRA paperwork or your ban the box compliance in a while, form an internal working group of kind of who are our subject matter experts going to be, and then those are the people that can really kind of come together and work with operations and legal and HR to make sure that it's all done properly. Consider a privileged program audit. We do those all the time. They're not, terrible amount of work. And then always, anytime any firm, whether it's me or anybody else, tells you these are things that you might want to consider in terms of compliance, make sure those identified opportunities make sense. Because as I said before, you know, what works for company A may not work for company B, and this is not off-the-shelf stuff. Everybody does things differently. So with that, we have a few minutes for some questions. So I will go ahead and answer any questions we have.
Okay, so Jennifer, we've got time for just a couple of questions. We
Okay.
got one from, just recently came in from Mary. What language would you recommend instead of ineligible for hire?
Oh, well, ineligible, I mean, this is because we're recommending an individualized assessment. And so, you know, if you have grids, this really is focused more on grids. I'm not as opposed to ineligible for hire as I am fail, because fail just sounds terrible. But if you have some sort of grid, you know, I'd have to think about that. But just make sure you don't have fail or disqualified. Needs review is always a much better term, especially if you're doing a needs review or an individualized review, because then, you know, like I said, the EEOC wants you to do a review and they don't like anything that suggests that people are just automatically excluded. So if you're able to change it to needs review, or, you know, and this is with respect to your review process. This isn't with respect to your adverse action notices. I mean, once you tell somebody they're not getting a job, you can say you're ineligible for hire in that notice. That's fine.
Okay, thanks. Next question is from Kim. In regards to adverse action, in some states you have to offer before you run backgrounds. What advice would you have in those situations?
Well, you provide them a conditional offer. You say that you make clear the offer is contingent on the background report. You provide them the disclosure and authorization. They sign off. You get the report. If there's issues in it, you follow the pre-adverse and adverse action process. And that's why I was saying that, you know, because you don't know how long it's going to take, right? So you make the offer, hope the process works out, and that you can put them to work. If you give them a start date and then something comes back, you may have to say, oh, wait a minute, we're going to put the brakes on this. So if you're, I guess the short answer is if you're doing it post-offer, you have to still do all this process. It just essentially delays their start date, really. You didn't complete the background check before the offer, so you can't just have them sign the offer and then the next day start.
Okay, we got time for one more from Kevin. Can you speak to how these ban the box laws apply when the applicant is in one state and the employer is in another?
Yeah, so that was one of the things I talked about, and that really is going to depend. You know, Los Angeles, we know because of what it says that it only applies if the job is in LA. New York City, it kind of depends if the interview is actually happening in New York City. If the person lives elsewhere, then you probably have to apply New York City. It's better if you want to have kind of just a general rule to just apply the law of the state that's most favorable to the person. If they're in Georgia and California, if you're looking at Georgia and California, California is more favorable. If you're looking at California and Washington, those both are similar, and so you'll have to look at them and make sure you're complying with both. It's not an easy answer, I know that, I'm sorry. It's just kind of one of those that's very unclear, because a lot of these laws don't talk about, oh, it only applies if the job is here, or only applies if the employer is here, and that's, you know, fortunately what Los Angeles did for us.
Great. Well, that's all the time we have for questions. Jennifer, thank you very much for joining us today. What a great session with lots of very helpful information.
Great. Thank you for having me. I really appreciate it.
Thanks. Well, I would just like to wrap up. So if we could just go to the next slide. We'd like to, at EPAY, for you to remember us. I know we have a lot of customers on the line right now. And we also have some folks that might be joining our community. Just to tell you a little bit more about us, we have a full human capital management platform that goes from applicant tracking and HR and onboarding to time and labor management and payroll and even performance management. We work with clients all over the U.S. and our time and labor management platform is installed all over the world. But we have clients anywhere from probably about 100 employees on up to 10,000 on our payroll system. And then again, on our time and labor system, we can handle clients of even larger sizes. So we would love to work with you as your human capital management provider. and offer you the high customer satisfaction that we offer all of our others. Again, we like to always continue to present types of content like this, such as the Seyfarth Shaw series, where we're able to give you information to help you run your business better. So continue to watch some of our content that is out there. You can go to our website. You can also sign up for our blog there, and you'll continuously get news on different topics such as this and notices on different types of educational webinars. Thank you again for joining us. At the end of this, you'll have a quick survey, and you'll be able to tell us if you'd like to take a tour or see more about EPAY systems. So with that, I'd like to thank you from EPAY Systems and turn it over to Hester.
I'd like to thank our presenters as well as all of you for joining us today. If you'd like to view this webcast again, the archive recording and slides will be available for up to 7 days for our free members and without restrictions for those with our certification membership. The webcast credit will show up in your HR.com account within 2 business days. We will also send you an email with the credit information. Your feedback is important to us. Please take a moment to fill out the exit survey that opened in a new browser page on your computer. This concludes our webcast. Enjoy the rest of your day.